This is the Hidden Killers Podcast with Tony Bruschi and continuing coverage of the case against Bryan Kohberger.
So here's the move Bryan Kohberger's legal team just tried to pull. They walked into court and they said essentially, we can't fight what we can't see. And because of that, the court should strike the death penalty. What do they mean by what they can't see? Bold strategy, right? You think they'd be saying, they're not giving us what we need. It's actually quite the opposite of that. We'll talk about it in just 1 second, but first, be sure to press subscribe wherever you are watching this on YouTube so you don't miss any of our coverage on this case. Comment. We'd love to hear your thoughts on it. Give us your insight. Give us what your thoughts are. It can be different than mine. It can be different than the others. That's fine. That's how we have a dialogue, and that's how we learn and grow and understand these cases better, as long as the arguments make sense and they're not just, pulled out of thin air. So please do that. And if you're listening on the podcast, press subscribe wherever you're listening there. We do greatly appreciate that. And also do check out our YouTube where you can join in on the conversation. So their argument, it wasn't about innocence or guilt. It was not about a new piece of DNA or even a surprise witness for that matter. It was about the volume, the sheer bulk of what the prosecution handed over in discovery. According to the defense, the state dumped a mountain of digital evidence so massive, so messy, and so unfiltered, it amounted to a constitutional violation. Except there is no such thing for that. And because of that, they said the death penalty had to go. Let's put some numbers to that mountain. 68 terabytes of data. That's terabytes with a T. 13,000 photos. 15,000 business video clips. 8,000 residential ones. Dozens of phone and other digital devices, all collected in the aftermath of the Idaho student homicides and all handed over to Kohberger's team. The defense called it a data dump, said it wasn't even searchable in parts, no indexes, no easy way to review what was relevant, like trying to do a book report when someone hands you a warehouse full of shredded documents, except they weren't shredded. They were right there. It's now your job to work through it. And I know that number sounds really huge. Video files take up a lot of memory. It's not 68 terabytes of text. That would be probably every book in the world. That is not this. You have all those video clips, probably a majority of them having absolutely nothing on them. There's ways of going through this stuff. There's ways of working through these files. It's not 1985 where you have to have, your legal clerks reading every single. There's technology that can help you work through this. You can't just go, this is scary and hard. I mean, that's what they're going to try to get the death penalty off the table, but it's a task. Without a doubt, it is a task. But there's ways to do it. That's where the judge drew the line. The court ruled that defense couldn't turn around and complain about the weight of the very load they insisted on carrying. They'd asked the state to hand over everything, raw and unfiltered. So the state did exactly that. No games, no gimmicks, no filters. The same format it was received in from law enforcement agencies passed directly to the defense's server. And to help them make sense of it all, a 320-page index describing where each file was located, what it was, and when it was found, plus all the FBI materials, the bulk of the discovery, were searchable. The court noted that multiple steps had already been taken to make the job easier. This wasn't some sloppy handoff. It was comprehensive data transfer, and the defense had been in possession of it for over 2 years. That timeline matters, because it wasn't like they got hit with a last-minute hard drive where they expected to magically comb through it in 10 days. No, this process started back in early 2023. Kohberger was arrested in December of 22. His attorneys were officially on the case just weeks later, and discovery began almost immediately. So when they claimed they were running out of time or resources, the court looked at that and said, you've had time. You've had access. And if you needed help, you should have asked for it. But they didn't. Instead, according to the court, the defense never once came forward to ask for additional staff, special software, or even organizing the files, not even when they realized how extensive the discovery would be. And more than that, lead counsel reportedly insisted on reviewing all of it personally, not framing it out to junior staff or associates. She wanted to do it herself, which might sound admirable in theory, but in a case this size, that's like personally trying to inspect every grain of rice in a silo and then claiming you're overwhelmed. I get you want to be in control of what's going on. You want to know what's being handled here, but you got to be realistic about it too. To make it more interesting, she also chose to take on another capital case at the same time. The court saw that as a choice, a strategic one, not a constraint. Now let's talk about what really matters in motions like this. Brady material, that's evidence that could help the defense, anything that might reduce punishment or cast doubt on guilt. The defense said they couldn't identify any such evidence because of the chaotic way the discovery was shared, or because it doesn't exist. But here's the thing. The burden of proof is on them. You can't claim Brady violations in the abstract. You have to point to something specific. A document, a clip, something that was hidden, suppressed, inaccessible, or just hadn't been found yet. And they didn't. They just said he likes to look at the stars in the sky. And got a bunch of rubes online to go, yeah, he's innocent. It's all a lie. With no evidence. Just like people want to just scream the word cover-up and conspiracy. And you ask them why? How is this? And then if they give you an answer, which 9 out of 10 times they don't, but if you do happen to get one and you listen to it, it's, I don't know how to explain it. It's kind of like listening to Alex Jones talk about Sandy Hook parents being in on a conspiracy of their dead children. It's just ludicrous, and it makes no sense, and the arguments don't seem very based in reality. Now, I'm all about hearing other sides. I think, well, hopefully a lot of people are. I don't want to say most are. I think accurately say that, but I certainly do when they make sense, when they're grounded in solid reality, when they actually have receipts to go along with what you're talking about, like Delphi and the Richard Allen case. That's one where the official narrative doesn't make a lot of sense. The story makes a hell of a lot more sense. This is not that. The judge pointed out that they had not identified a single piece of Brady material that was buried, let alone withheld. Yeah, no proof of concealment, no digital sleight of hand, and under federal and Idaho law, that matters. Courts have ruled again and again that overwhelming volume alone doesn't make something a Brady violation. If the material was handed over, even if it's a mountain, it is still considered disclosed. You asked, you get. The prosecution has to go through the same mountain of stuff too. You both got the same amount of cookies. Only one of you wanted more time at recess. Or you decided to stay inside and play look at the stars rather than look closer at the evidence you've been given. Or maybe you just knew all along that in all that evidence, you weren't going to find anything. So why waste the time over there? Invest your time and efforts into the motions, into anything you can point out as being some sort of a violation, something where some T wasn't crossed or I wasn't dotted, and hope to God that that works, because the evidence in this case does not work out for your client. And that's what Ann Taylor has been doing. And honestly, probably the right move. But again, it kind of came back to this, and she had to go, I got to say something about this, see what sticks, because nothing else has. The defense also floated another argument that the state has some unfair advantage because they were allegedly using powerful case management software, specifically a program called Prosecutor by Carpal, while the defense was stuck with more basic tools. The software, they claimed, allowed prosecutors to instantly search files, transcribe video and audio, and generate reports. The state, for its part, denied that. They said they weren't using any such features. In fact, they said their process was spreadsheet-driven, manual, not some high-tech edge. Maybe you should be using that, don't you think? Learn about the features of your software. You'd be amazed what they can do. And the court believed him. The judge found no evidence of technological imbalance, no haves or have-not scenario. In fact, the court pointed out that the way the state transferred the data, raw and unaltered, was actually better for transparency because it meant no editing, no manipulation, no chance of curated evidence. So with all that in mind, the judge refused to strike the death penalty. But Kohberger's team wasn't done. They also asked the court to force the state to organize the evidence. I know you gave me all the ingredients, but could you bake the cookies for me? Sorry, I'm doing 50 other things over here. Here's the ingredients. Bake your own. To highlight anything helpful and point out so-called hot documents and basically mark up the haystack so they could find the needles. Yeah, let's have the prosecution do that. And you know how this works. It's not how that works. And again, the court said no. Why? Because once you start requiring the prosecution to highlight helpful evidence, you open the door to endless legal squabbling over what should or shouldn't be flagged. What one side thinks is helpful, the other might think is completely irrelevant. And in a case where the defense is well-funded, fully staffed, and has plenty of time, that kind of special treatment just doesn't fly. If you were on the prosecution and you were evil, you could mark up things that really aren't important and say, here, we think these are important. And it's up to them to figure out whether you're being real or they'll call your bluff. Or how about better yet? Each side gets the same stuff, which they did, and each side goes through it the way they want to. Not, they have better tools than we do. Okay, well, you're an independent attorney, so get those tools. They're out there. You can get them. You're paying God knows how much for some of these independent witnesses to come in and testify on your behalf that are kind of ludicrous. That costs hundreds of thousands of dollars. I think you might be able to afford the software. Or if you noted it early enough, maybe you could have gotten a copy. I don't know how that works, but look, complaining about somebody else through their window because you don't live in that house. No one cares. Do your job, do your work, and find what you will find. You have the same material. No one's going to give you pity because it takes a lot of time. That's your job. That's what you signed out for. Figure out how to delegate, figure out how to do it. It's not for the prosecution. The judge noted that some courts do require organization, especially in cases where the defendant is incarcerated, under-resourced or up against federal agencies with unlimited bandwidth. But Kohberger didn't fit that bill. Again, he's got a full legal team, investigators, mitigation specialists, and a lineup of experts. The court even nudged them. If you need more help, ask the money judge to get it. But don't ask the trial court to babysit discovery. In short, the court saw no foul, no bad faith, and no burden that hadn't already been voluntarily accepted. And so it denied the motion flat out. The death penalty stays on the table, the discovery remains as is, and the court's message to the defense is loud and clear. If you ask from the haystack, don't blame the barn when you can't find the needle. What do you think on all this? Let us know in the comment section of this video on YouTube. If you're listening to our podcast, please go comment on our YouTube video. Check out our YouTube channel. You can watch all of this and join in our conversations. But press subscribe wherever you're at right now so you don't miss any of our coverage on this case and others. All right? There you go. That's the latest. More, arguments out of the Kohberger camp that don't really make sense. But hey, that's how the game's being played.
Want true crime coverage all day, every day? Press subscribe now to the Hidden Killers podcast and True Crime Today and get the latest cases delivered right to your feed.